Joining us on the line is Misty Marris. She's a trial attorney based in New York City, specializing in the defense of clients in entertainment, sports, employment, civil rights, and sexual assault and abuse cases. And she is currently appearing and providing gavel-to-gavel coverage and analysis of the Derek Chauvin trial for CNN HLN. Misty, thanks so much for joining the show. Really appreciate it.
Yeah, thank you so much for having me, Ben. Happy to be here.
Yeah, so let's talk about the charges in this case. The prosecution does have a high burden, obviously. In any criminal case, you have to prove beyond a reasonable doubt. They're charging second-degree murder, third-degree murder, and second-degree manslaughter. And those charges are not as easy to obtain as they sound. So can you walk us through what those charges mean?
Yeah, absolutely. So first of all, we have the second-degree murder charge. Now, that means that the state has to prove that Chauvin caused George Floyd's death while committing an intentional assault, resulting in his unintentional death. So obviously, there's a high bar there to show that Chauvin actually committed the underlying assault, which is required in order to establish that charge. So that's the first and the highest level charge. Then we have third-degree unintentional murder. Now, the standard there is that it's extreme recklessness to the risk of causing death. Now, Ben, this charge was actually thrown out prior to the trial because, in general, this relates to the type of case where you have somebody shooting a gun in a crowd, right? It's not a danger to one specific person. It's a danger to a group of people, and somebody gets killed as a result of that reckless conduct. So it's a little out of place here in this trial, although now it's actually it's part of the case. So it's going to be something the jury will hear jury charges about and will ultimately deliberate on. Now, last, we have second-degree manslaughter. This is the lowest level of the charges. This is when somebody causes the death of another by culpable negligence, where they create an unreasonable risk and consciously take chances of causing death or great bodily harm. So this is more than a negligence standard. It's a recklessness standard. So that's where the state has to go to prove that Chauvin is guilty of a crime on any of those charges. And of course, as you said, the standard is beyond a reasonable doubt, a very high bar for any prosecutor to prove in any case.
So frankly, as an observer of the trial, I did an entire hour yesterday talking about how rough the trial had gone for the prosecution up until yesterday. So yesterday, the prosecution seemed to have a better day. Prior to that, it seemed like the prosecution was having a bit of a tough time because the defense seemed to be making a fairly compelling case that at the very least causation ought to be in doubt as to George Floyd's death, because he was saying, I can't breathe, before he was on the ground, because he had deadly levels of fentanyl in his system by some calculations, because he had a history of having overdosed on fentanyl, according to his former girlfriend. And they had also gotten testimony from prosecution witnesses about things like the use of force that suggest that it's a little bit more complicated than the prosecution had originally made out. Essentially, the prosecution had made out that Chauvin was doing something that was not approved by the Minneapolis Police Department. A lot of those witnesses were then called upon to talk about complicating factors, crowds that were threatening, or how or alternatives that theoretically Chauvin could have used that were actually harsher than the level of suppression that was being used, or the possibility that Floyd could have been like other suspects and popped awake after falling unconscious and stuff like that. How did you think the trial was going for the prosecution?
Well, look, Ben, and I've been covering this gavel to gavel, so I've been watching it with the jury every single day. So look, the first week of the trial was tough, right? From a defense perspective. And I'm a defense attorney myself, so I tend to look at things through that scope. You had bystander witnesses, you had a lot of emotional video. Of course, that video is difficult for anybody to watch. There's no ifs, ands, or buts about that. And there's not really that much the defense could do or much traction they're going to have with these bystanders. There's not a whole heck of a lot, especially when the court really, in my opinion, and of course, we defer to the judge, he's the one making the evidentiary rulings, allowed for a lot of testimony that I think in some cases would not have been relevant, and another judge might have made a different decision. For instance, the bystanders were permitted to testify about how watching the incident made them feel. So as a defense attorney, I'd be objecting, dancing all over the room, jumping up and down, saying this really isn't relevant to the case. We also heard from a bystander who practices MMA. He in my view, he was a lay witness, but he almost bordered on what would be considered an expert witness, which is really not appropriate under those circumstances. That being said, defense objects where they need to object, preserves issues for appeal and whatnot. That's fine. Now we move into the second week of the trial, where we heard from the use of force experts. Now, why do they matter? Well, use of force is a critical issue in this case. If the use of force that Chauvin applied to George Floyd is reasonable, acquittal. Right. So the use of force is really a key component. Now, who did we see? We saw a variety of officers who do training on use of force for the Minneapolis Police Department. We saw Chief Arenado. We saw other officers who train in other aspects such as EMS, critical care, and whatnot. And then it all culminated with an expert, Sergeant Jody Stinger of LAPD, who was a paid expert for the prosecution. And Ben, I got to tell you, this week, the prosecution fell apart. And I'm talking about the week of the use of force experts for a few reasons. So prosecution brings on all of these witnesses, and I'm going to focus on Chief Arenado because I think that I understand optically, as a trial lawyer myself, the police chief coming out before a jury and saying this use of force is unreasonable. Sure, that has an impact on the jury, right? They're thinking, oh my gosh, this guy, he's been on the force for X amount of years. You know, he's the head of everything. His opinion matters. But I found it to be interesting because even on direct examination, the conclusion was this use of force was absolutely unreasonable. There was no reason to do it, blah, blah, blah. But how did we get there? Well, the answer to that question and the rationale to draw that conclusion was because it doesn't fit in with the ethics of the police department. Now, to me, Ben, and you're a lawyer as well, I was expecting a detailed, factual analysis in the testimony of, well, our policy says X, Chauvin did Y. Look at the video. Here's where there was a problem. Here's where the force was unreasonable. We did not get that. And that was the direct examination. And at that moment, I said, uh-oh, this is not going to go well for the prosecution. And then the defense attorney, Eric Nelson, did an excellent job on cross-examination of calling out some very, very critical testimony that tends to undercut that conclusion altogether. What do I mean by that? Well, when we talked about the policing policies, Eric Nelson went through a detailed examination of what those policies say and what they are. In essence, he pointed out the fact that every single policy has these qualifiers. If reasonable, if practicable, if time allows, if safe to do so, and that it's not really so easy to say, we got all these papers that say X, Y, Z. The application of those policies in an actual situation with somebody that you're trying to arrest is a whole different ballgame. I thought it was very interesting that the chief also specifically said, when asked, when should Chauvin have released or stood up, released George Floyd? He said, when he stopped resisting. Oh, well, now there's testimony that Eric Nelson is going to use. So you're saying he's resisting. This flies in the face of a prosecution narrative that there's this difference between active and passive resistance. Essentially, with all of these experts, Eric Nelson was able to get information on the record that says, look, it is not that simple. Just saying that this is unreasonable, well, you're not drawing that from a logical analysis of why. It's just a conclusion without any basis. And I think that's where they really fell apart. This use of force expert, and actually one more comment on Arenado, because I think this is a really important point to make and something that Eric Nelson is going to hammer home when we ultimately get to closing arguments where this is where it will all gel, right, Ben? So all of the information that we're getting out on cross-examination is going to be presented in a nice little package to the jury, and it's going to be the defense narrative. He said to the chief, when you're talking about unreasonable force, you're talking about an employment decision. You're talking about a decision you made to terminate Officer Chauvin. Well, let's not conflate that with whether or not a crime was committed. Completely different standards. That's super impactful.
So, quick question for you. So,
sure.
There were some other use of force experts who I thought really were not good for the prosecution. Johnny Mersel was an MPD use.
You're going to say Mersel, Ben?
Oh yeah, Mersel was terrible. I mean, they're so bad that it's almost as though Nelson called him as a defense witness. He specifically said that he had disbelieved suspects' claims of medical emergency. He had suggested that drugs can make suspects stronger, that suspects can resuscitate after being unconscious. I mean, it was basically exactly what the defense needed in that case. But
and in fact, he said he's had suspects say, I can't breathe as an excuse with respect to getting arrested, which was, I thought, amazing. Could that have been more on point?
Exactly.
For what the defense would like to
but the one question I wanted to ask you is yesterday, the prosecution brought forth a couple of medical experts, and one of those medical experts in particular, Martin Tobin, he basically testified that he could tell from the tape how George Floyd died. And I've never seen anything like that. I mean, to be honest with you, I mean, I haven't watched tons of criminal trials, but I've never seen anybody claim that they can watch a videotape and tell cause of death that it is not drug-induced, that it is not heart attack-induced, that it is not anything induced, simply by looking at frame-by-frame respiratory rates of somebody dying. That seems like, frankly, I'm surprised that Nelson didn't push harder on that.
Correct, Ben. And it's interesting because what Nelson did is he did say, you're a pulmonologist, correct? You're not a pathologist. So essentially, he got that on the record that, look, you're looking at this from one particular point of view as a pulmonologist. You're not looking at it as a full picture type of point of view. But I do agree with you. And look, Dr. Chauvin was a great witness from a jury perspective. And that's because he really diluted very complicated concepts down into something that was very manageable for a jury to consume, applying, as you said, this science that quite frankly, I've never seen that before. And I cover trials as a significant portion of my job, to the video and then applying the medicine to that point. But here's where I think that this is going to be a big problem for the prosecution. So Dr. Chauvin essentially said, there are no other factors that caused George Floyd's death. It is only the fact that Chauvin was on his neck and or back. He did say that. He said it didn't really matter. Either way, neck or back, whatever, it still is Officer Chauvin who caused his death on this very precise analysis with respect to his lungs and all of that, as you said, from watching the video and making this medical analysis. But Ben, who's coming down the pike here? The medical examiner, Dr. Baker, who lists other, specifically in his report, significant factors, such as drug use, such as a heart condition. And look, as much as Dr. Chauvin that day was the star of the show and seemed to be an excellent witness for the prosecution, I think that's going to be optics. Because once the defense is able to capitalize on the fact that you have a report from the medical examiner that lists these other factors as being a part of the analysis of what caused George Floyd's death, well, now this expert loses a lot of credibility. And I think a lot of us watching the trial were surprised that the prosecution's expert was going so far to say nothing else contributed to the death. I don't think anybody expected that. We thought it was going to be many contributing factors. And then the argument is that Officer Chauvin's actions are what's a substantial factor.
Right.
But look, I think they're going to be able to take that apart quite a bit as more medical experts. A defense is going to present an expert. They don't have to, but
they certainly will, yes.
They certainly will, of course. But even just with the medical examiner, Dr. Baker, that's going to be a tough road to hoe. We know Dr. Baker, after creating the report, also in an interview with police said that if George Floyd had died in his apartment, he would have called it an overdose.
Yep.
So it's not going to jive. And that's where, although yesterday seemed to be a wonderful day for the prosecution, no doubt, we can't look at it in a vacuum. We got to look at what's to come and think about what the repercussions of that are going to be.
Well, that's Misty Marris, trial attorney based in New York City. You can follow her gavel-to-gavel coverage of the Derek Chauvin trial for HLN. Really appreciate your time, Misty.
Thank you very much, Ben.
I hope you enjoyed that clip from The Ben Shapiro Show. If you did, go ahead and hit the subscribe button so you stay up to date on all of our future content.